Lawyers in Nigeria are not happy with Justice James Omotosho. Nigerian lawyers are angry with Omotosho because of the way he handled NNAMDI KANU'S case. The news just broke and these lawyers are already speaking out, voicing out their anger. Many of them are very, very angry with James Omotosho and they're already calling on him, voicing out their anger. Senior lawyers differ on conviction and life imprisonment of Mazi NNAMDI KANU. Omotosho is finding it difficult to convince these lawyers. The decade-long trial of indigenous people of Biafra IPOB leader Mazi NNAMDI KANU finally reached a dramatic climax last week when the Federal High Court in Abuja convicted and sentenced Mazi NNAMDI KANU to life imprisonment on terrorism charges, closing one of the most contentious criminal proceedings in Nigeria's recent history. We must move on. 10 years ago, the case meandered from judge to judge. Just pay attention, punctuated by arrests, releases, flight from the country, extradition controversy, that's kidnap. People call it kidnap. Workouts by lawyers, courtroom tensions, and political undercurrents that made every hearing a national spectacle. Of course, even at this moment, the matter is still in the front burner. And even we here in Noble Media, we have a correspondent down there in Nigeria, and we are always giving you updates. Anything happening in Nigeria, we have our people down there. We're always giving you updates of what is going on. The culminating judgment by Justice James Omotosho arrived with unusual speed. Pay attention though. Typed, signed, and released to both sides within 24 hours. That shows that maybe they have already typed the judgment many days or many weeks ago, just waiting for the whole drama to unfold so that Omotosho will read out what was given to him to read. Typed, signed, and released to both sides within 24 hours, instantly triggering fierce debate about its substance, process, and broader implications for justice, federalism, and national security. For some legal analysts, the court merely applied the statute to the evidence. For others, the judgment sat uneasily on shaky legal foundations. In this edition, Vanguard Law and Human Rights spoke to 4 senior lawyers whose sharply contrasting positions reveal a profession split between those who hailed the judgment as a triumph of due process and those who insist it is nullity awaiting to be overturned by Court of Appeal. You watching this video, come under the comment of this video and type, nothing must happen to NNAMDI KANU. Nothing must happen to NNAMDI KANU. Tinubu, nothing must happen to Mazi NNAMDI KANU. Type it and also type, Biafra must never die. Biafra can never die. Biafra will never die. We must move on. Judge went extra mile for fair hearing. For Wale Edun, senior advocate of Nigeria, the verdict was a predictable outcome of a trial in which, in his view, no judge in recent memory gave a defendant more latitude to defend himself. The former Nigerian Bar Association welfare secretary described the case as a 10-year long legal odyssey that tested the endurance of Nigeria's judicial machinery. Edun praised Justice Omotosho's dexterity and probity, insisting that the court demonstrated uncommon diligence. He said the case took 10 years to conclude after going around several judges until it was transferred to the Court of Justice J.K. Omotosho. Until it was transferred to the Court of Justice J.J. Omotosho, Justice J.K. Omotosho. The trial judge granted accelerated hearing and concluded the case in less than a year. I commend the case management style and judicial probity of the court. Don't forget to type in the comment, Biafra will never die and nothing must happen to NNAMDI KANU. To Edun, fairness was the central theme. According to him, the prosecution witness were cross-examined. Defense counsel, led initially by eminent Silk, Kanu Agabi, had every opportunity. After the defense chose to terminate counsel service, the judge adjourned several times for the defense to rethink his desire to represent himself. He pointed out that the court even attempted to cushion the risk of self-representation. The judge offered to deploy counsel from the legal aid counsel, but the defendant rejected it. The court practically pleaded with him to open his defense. No reasonable person who followed the proceedings can say he was not given a fair chance. Pay attention. He added that the legal consequences of refusing to defend oneself are always severe. Always severe. That's for Wale Edun. It is settled law that there is defendant's fair, that where a defendant failed to open his defense, he is deemed to have rested his case on the prosecution. It is a dangerous strategy. Justice is a three-way traffic. The defendant, the prosecution, and the public. Don't forget to come under the comment of this video and type, nothing must happen to Nnamdi Kanu Tinubu. Absolutely nothing. Nothing must happen to Mazi Nnamdi Kanu. And you can also drop a prayer for Nnamdi Kanu in the comment section, because Nnamdi Kanu is going through a lot right now in Sokoto. Edon emphasized that courts cannot be swayed by politics. A trial judge is never concerned about the politics of the case. His only duty is to determine whether the prosecution has proved the offense beyond reasonable doubt, period. But he pivoted sharply to politics in his closing reflection, urging federal authorities to embrace reconciliation. This does not deter from the prerogative of mercy committees' power to recommend pardon. Convicted looters have been pardoned. We need healing now. That means Nnamdi Kanu should be pardoned. That is what Wale Edu is inferring. He framed Mazi Nnamdi Kanu's case as a symptom of a deeper national malaise, one rooted in structural imbalance, divisive policies, and failures of leadership. This is something that Omotosho is supposed to know. This is something that even Tinubu knows very well. Because it is failure of leadership that is resulting to all the problems in Nigeria, including the IPOB issue. Nigeria is a federation of more than 300 tribes. We still operate quota system and federal character 65 years after independence. These policies have replaced merit with mediocrity. Edon warned that violence cannot drive reform. No government will allow violence or threats that can cause breakdown of law and order. Look at Libya, Sudan, Syria. Nigeria cannot afford security collapse. But of course, security has already collapsed long ago down there in Nigeria. His prescription is political restructuring, empowered governors, state police, and better leadership selection. Nigeria is too big to be controlled from Abuja. The people must agitate through their leaders for devolution. Governors must stop worshipping Abuja. Nigerians must stop electing jokers. State police is a must. Kanu should never have defended himself. Another lawyer, Okpara SAN. Victor Okpara SAN, in his assessment of the judgment, adopted a middle ground. He opted not to attack the judgment's substance, but questioned the integrity of the procedure, particularly Kanu's decision to sack or disengage his legal team and attempt self-representation. Even Nelson Mandela did it in his time. For Okpara, terrorism cases demand high evidential threshold and professional defense. He said, what surprised me was that Kanu dismissed every competent legal team, in my view, and choose to defend himself. Defending yourself in a criminal trial requires forensic skill, emotional intelligence, and deep legal knowledge. Unfortunately, we did not see him present witnesses or counter the prosecution's evidence. When that happens, the judge has little room. If the prosecution's evidence is unchallenged, it stands. Having said that, I hope you are following. Pay attention, we are driving to somewhere. It is important to interrogate the procedure. I do not believe a defendant facing a defense that carries life imprisonment or death should ever defend himself. Section 349 of the Administration of Criminal Justice Act, especially subsection 6, clearly said that a defendant facing a capital offense shall not defend himself. So he's saying that Kanu made a mistake. In such cases, the judge should assign counsel, either through legal aid or a doc brief. I do not know whether that was done here. Once his lawyers withdrew, he had no representation, and in my view, the judge should have assigned counsel from legal aid, the Ministry of Justice, or even the Nigerian Bar Association. The sanctity of the court must be preserved. A defendant without legal training should not be allowed to defend himself in such serious matters. Pay attention. The law states that a defendant facing capital charges shall not be allowed to represent himself. It is a mandatory duty imposed by the law, not a discretionary matter. However, even if counsel is assigned and the defendant rejects the lawyer, another question arises: does his constitutional right to counsel of his choice override that provision? These are issues for the appellate court. Again, I do not know if the judge gave him the statutory opportunity, if NNAMDI KANU was given that statutory opportunity. Let's move on. From what I see, Mazi NNAMDI KANU'S case was not hopeless. There were many possible defenses. I would have preferred that his very experienced lawyers handle the case using their forensic skill. I do not support the strategy of disengaging or dismissing them. Do you buy into this argument that Kanu made a mistake by dismissing his lawyers? Regarding appellate prospect, Okpara's answer was measured. Does he stand a chance on appeal? It depends on the grounds. The Court of Appeal is not a charity home. If he has solid grounds, the court will consider them. Judgment built on nothing cannot stand. This is another senior lawyer in Nigeria, Evans Ofili. Human rights lawyer Evans Ofili offered the sharpest criticism of the verdict, describing it as legally defective on 3 fundamental grounds. 1. Absence of valid statutory basis. 2. Insufficient evidence. And 3. Procedural irregularities. So there are 3 foundational grounds that makes NNAMDI KANU'S case invalid. The sentence of NNAMDI KANU is invalid according to Evans Ofili on 3 bases. 1. Absence of a valid statutory basis. 2. Insufficient evidence. And 3. Procedural irregularities. For Ofili, the first and most damning flaw is the legal foundation of the charge. He said, the first and most elemental objection is statutory. Criminal law proceeds on maxim, nullum crimen sine lege, not crime without law, and its corollary that a court may not convict on a basis that lacks a current legal foundation. The Latin adage, nothing comes from nothing, captures this point with equal force. A conviction cannot validly derive from a legal vacuum. A conviction cannot be derived from a legal vacuum. Convicting NNAMDI KANU, you cannot convict NNAMDI KANU on a legal vacuum. Pay attention. If the Terrorism Act under which the accused was charged, had been repealed period to or at the time of prosecution, the court's exercise of criminal jurisdiction in reliance upon that act would have been without legal underpinning. The consequences are not merely technical. A law is the predicate that defines the prohibited conduct, prescribes requisite mens rea, and establishes the penalties. Absent that predicate, there is no correctly defined offense to try, no statutory element to prove, and no lawful sanction to impose. That is to say that Omotosho really lacked any sanction to impose on NNAMDI KANU. There are further legal nuances. The temporal relationship between repeal and the alleged offending conduct can matter, and the legislature intention regarding retrospective application will determine whether prior conduct remains punishable. But those distinctions only reinforce the central point. The court must first determine whether the statute remains in force and applicable before it can proceed to adjudicate guilt under that statute. If a court ignores or misapprehends that statutory question, any conviction it pronounces risks being void of a legal foundation. That means from Ophili's point of view, what Omotosho did already lacks a legal foundation. Please, you watching this video, what do you think? Come under the comment of this video and type, nothing must happen to Nnamdi Kanu. Absolutely nothing. Tinubu, free Nnamdi Kanu now. Nothing must happen to Nnamdi Kanu. Also type, Biafra must never die. Biafra will come in our lifetime. The second pillar of his critique is evidential weakness. No weapon was tendered. There was no direct proof tying him to violent act. There was no direct proof correlating Nnamdi Kanu to any violent action in Nigeria. They even have to accuse Nnamdi Kanu of inciting the NSAS protest. NSAS. How can you tie Nnamdi Kanu to NSAS protest? He emphasized that circumstantial evidence must be overwhelming. Uncorroborated assertions or reliance on dangerous speeches without nexus to violent act cannot meet the standard of proof beyond reasonable doubt. Beyond reasonable doubt. 10. And in Opheli's view, most alarming, is the court's refusal to hear a jurisdictional objection. Omotosho refused to hear Nnamdi Kanu's objection to whether Omotosho's court has jurisdiction to try him. Jurisdiction goes to the very heart of adjudication. If a court ignores a valid objection to jurisdiction, everything it does afterwards is a nullity. Very important. Elaborating, he said, the court must first determine whether the statute was enforced and whether it has jurisdiction. To proceed without resolving these questions is to invert the hierarchy of the rule of law. Opheli insists that the judgment is fatally vulnerable. Taken together, absent statutory foundation, insufficient proof, and a failure to entertain jurisdictional objection, the conviction is constitutionally and legally defective. The conviction of Mazi Nnamdi Kanu, according to Opheli, is constitutionally and legally nonsense, legally defective. Please come under the comment of the video and type, Omotosho releasing Nnamdi Kanu. Tinubu, nothing must happen to Nnamdi Kanu. As for the appellate prospect, Opheli opinion does. In such circumstances, the conviction should be set aside or remitted for fresh trial after resolving the threshold issues. He wants that the implication go beyond Nnamdi Kanu, saying, if court allows conviction where statutory basis is doubtful or evidential threshold unmet, they erode criminal protection. No conviction should be built on nothing. No conviction should be built on nothing. Absolutely. This is very important. It was compromise sentence. Or another senior lawyer in Nigeria is saying that convicting Nnamdi Kanu was a compromise sentence. Lagos-based public law expert Mr. Benga Ojo sees the verdict through a different lens. He described it bluntly as a policy judgment, compromised but necessary. He argued that the severity of terrorism charges ordinarily carries the death penalty, and that what happened to Mazi Nnamdi Kanu case was a carefully calibrated legal political balancing act. It seems like a policy judgment. The penalty for treason or treason-related offenses is death. The idea is to work out political solution like prerogative of mercy and release him after, or just say. So maybe they just did this life imprisonment so that the Tinubu can now release him later. Ojo believes converting Mazi Nnamdi Kanu was important to avoid setting a bad precedent. If Kanu had been released without full trial, that would have been a very bad example. It would embolden other separatists to think trial can always be compromised. Are you following? If you are still here, let us know in the comment section. The law lecturer also, through his support for a fusion of firmness and mercy, he said, let the judiciary do its work. Any similar offenders will go through the rigors of trial and punishment, but the government should temper justice with mercy and work out political solution with stakeholders among Igbo leaders. But it appears that the Igbo leaders are afraid of stepping in for Nnamdi Kanu, or they are so selfish that they don't want Nnamdi Kanu to be freed. Their own interest is just 2027 re-election, taxation, looting, and saving money abroad. Ojo described the overall outcome as a welcome development, arguing that it protects the integrity of the judicial process while keeping the door open for political reconciliation. Among all these 4 lawyers, these senior lawyers in Nigeria, who do you agree with? Let us know in the comment section. Like this video, share this video. Very important. Click on join to become a full member. If you have not subscribed, click on subscribe, and most importantly, go over to our channel. You will see other videos, very important videos on this matter. Now, there's another video on the screen. Click on it and watch now.